Hi, my name's Amy, and today's video topic is Certified Workers' Compensation Healthcare Networks. We are making our way through the obstacle course for the boot camp. You'll see that we're on the second to the last challenge, and it is the climbing wall. Our learning objectives today is to learn what is a Certified Workers' Compensation Healthcare Network. How do you find networks in your area if you're a healthcare provider, and how to apply to become a contracted network provider, and understand the importance of your intake and registration and identifying the network status of that particular injury. We call those claims in our system. So hopefully you will not fall off that climbing wall, and you are lucky today to get over that to the next challenge. So Certified Workers' Compensation Healthcare Networks. The purpose of today's video is to educate system participants, and the information being provided is accurate as of March 17th, 2026. And we're doing our best to educate you, but the insurance code, the labor code, and the administrative codes, both for the insurance side and for the workers' comp side, are important to know, because if there is ever a discrepancy or a dispute, the words of the insurance code, the labor code, and the administrative codes, part 1 and 2, are going to come into play to resolve any disputes or complaints regarding this topic today. An overview of what we're talking about today is: what is a Certified Workers' Compensation Network? How can you join one if you're a healthcare provider? What are the network requirements? And review your network intake and registration procedures. Also, pre-authorization requirements will be talked about. Some exceptions to the medical billing and reimbursement as it relates to network. And dispute resolution. It's really important. There is a big difference in the network fee disputes that we want to talk to you about. And then the network report cards. So what is a Certified Workers' Compensation Healthcare Network? Let's start with the basics here. In 2005, the law was changed by the Texas legislature. It was House Bill 7 that added Chapter 1305, which is in the insurance code. This part of the code establishes and provides regulation of the networks, and also added to the labor codes 408.031, which says the injured employees out there can receive care through networks. So that was new to our system back then. But if there was ever a conflict between the insurance code and our labor code, that 1305, which is the insurance code, would prevail. So this is where the insurance code and the labor code work together. So you will have to know how to navigate to both the insurance code, the labor code, and the related administrative codes for network claim administration. So a network is defined by the labor code in 401.011 and the insurance code 1305.004. Both of these regulations say that a network is an organization that contracts with a carrier and forms a network of providers to provide services to our injured employees. It's important to know that Texas Department of Insurance certifies the networks to be able to operate in Texas. The Managed Care Quality Assurance, or MCQA department, handles the network applications and certifications. And just to remind you, we've showed this image in other videos, but to remind you, we are talking about Texas, which allows employers to choose to have coverage, workers' comp coverage, or not. So the ones on the right-hand side here are those employers. There's about 24% of our private Texas employers that have chosen not to have coverage. So those are called non-subscribers. So some of them will have no coverage at all. That means they've gone bare. And some of them might have occupational accident policies. We get lots of questions about how to bill these bills for these types of injuries that work for. There's some large employers that are non-subscribers in Texas. And even if they have these accident policies, we do not have jurisdiction on how you bill, collect, or if there's discounts taken or any of that. Our laws do not apply to the 24% of employers that have gone to the non-subscriber choice. Now, on the left-hand side, these are the employers, and of course, they do not include federal employers. So if you're dealing with Border Patrol or IRS or Post Office, we do not have jurisdiction over that. That's Department of Labor. But for those Texas employers that have chosen to have coverage, they're called subscribers. And if we've taught you in other videos how to check and see if the employer where they were injured had coverage on the date of the injury. Those are called subscribers again, and some of them, this can purchase a commercial workers' comp policy that may or may not have network options for that employer. The employer is the insured. They'll be making the choice to buy a policy that has a network or not. There's also employers that are certified self-insured, and the self-insured governmental employers like political subdivisions, which can involve a contract and a network also. So just know 76% of our employers in Texas fall on the left and 24% fall on the right. Could be some large employers on the right-hand side. Your intake and registration will have to understand that nuance is part of Texas regulation. You've got to find out if they had coverage. So employer participation in network. Remember, the employer is the insured. They're the ones that choose to to offer services or workers' comp coverage through their employees through a network or not. The regulation of 1305.004 says that a network is an organization that contracts with a carrier and forms a network of providers to provide services to injured employees. And we at TDI certify those networks. Currently, new injuries that are occurring in Texas, 50% of them involve a contract, meaning through networks, or maybe we'll talk about the political subdivision that can direct contract or have certified networks. In fact, that's the next slide. These are the three major ways that healthcare services are provided to injured employees of Texas employers. In the middle, 50% of new injuries fall under the non-network. That means there's no contract involved. These injured employees can choose any willing provider. They can choose their own doctor. They don't have to follow a list of doctors. Labor Code 408 and 413 govern the non-network injuries or claims, if you will. On the left and right are those types of healthcare delivery services that could involve a contract. Basically, they fall under basically the other 50%. On the left are those employers that have chosen to provide healthcare services to their injured employees through a certified workers' compensation healthcare network that's governed by the insurance code 1305. We call those network claims. On the right, these are the school districts, the sheriffs, the first responders, the cities, out there that are providing workers' comp coverage to their employees. It's under Labor Code 504, and these are called political subdivisions. They can operate one of three ways. They can have non-network situation where their employees can go to any willing provider and not have a panel of providers. They can operate like a network, so following the regulation in 1305, or they can have interlocal direct contracts with healthcare providers. So 2/3 of the way they can operate can involve contracts. So if you're dealing with a political subdivision, it is important that your intake determines whether a contract is required for your healthcare provider to treat that injured employee, that teacher, that EMS person, those political subdivision employees. So how do you find a network? On our website, you can find a network. So oftentimes we receive calls from InComp Connection where healthcare providers want to know how can they join a network and where are those networks and how to contact those networks. It's the network that creates and contracts with a panel of healthcare providers, and you can obtain the contact information available for each network on our website. You can search by the network name or by the location associated with the county in Texas. Currently, all 254 counties in Texas have some network operating in them. So it's pretty much all over Texas. Your intake and registration is going to have to be really good at determining whether that injury is part of a network or subject to a network or not. So on our website, you see on the top those 3 tabs. The one on the right, you have to click on the workers' compensation tab to get to our homepage. And never mind the A through Z on the top right. That is for the entire site. Now you can get to networks if you fish through there, but faster, just go to the workers' comp A through Z for most of our topics. A through Z that's circled down there, and you can go to N for networks. You see that networks that circled, certified workers' compensation healthcare networks are there. And then you're going to get to this page. There's a lot of information on here, but under the subheading information for injured employees, you can see that how do I find a certified WC net? That's for workers' compensation certified network. So click on that. And then we took a little excerpt and put it in the slide. You can see what it says here. You have 3 options to find networks. You can just go straight to a list of certified workers' compensation networks. There's 22 networks operating in Texas. You can look for your county. Say you're in Cameron County or Hidalgo County or El Paso County. You can search for the networks operating in your county where your clinic is by that option. And then you can look across the state of Texas map for coverage. So different ways to find networks. So once you find the network, we get a lot of calls asking for how can my provider become a part of that network? Well, first thing is find the networks that operate in your area, and then make sure your TexComp profile is up to date. So if you've watched other videos, you understand that provider means both facilities and individual practitioners. On the practitioner side, you have addresses and training and certification and financial disclosure requirements. That all needs to be up to date and accurate. And that's a good starting point. On the facility side, it's not on either side, it's not necessary that you have to have a profile, but if you do, make sure it's accurate and up to date. So we have a checklist for treating doctors, and it is on our website under that link, how to become a treating doctor. This gives you a checklist, including how to join a network on this checklist. So, and part of that is just keeping your TexComp profile up to date and your financial disclosures. This is geared towards an individual treating practitioner here, and you can follow that. So starting with, after you've updated your TexComp profile, there is a standardized application that you can use to submit to the network that you wish to participate in. It's the LHL 234 standardized credentialing application. I can't guarantee that the network wouldn't want another type of application filled out, but it's a good place to start. And we have that link there in your slide. Just remember, just because you want your doctor to be, or your home health, or your whatever, your hospital to join a network, Texas is not an any willing provider state, meaning just because you want to be part of, XYZ network, they have to take you. You have to apply directly to the network. It is a private contractual agreement between you and the network, and they don't have to accept you into that network. So again, just don't send your application to TDI. We don't broker those contracts. They're directly with the network. The network must complete the initial credentialing within 180 days before the healthcare provider is considered a credentialed provider with them. They must notify you, the healthcare provider, of their decision no later than 60 days after making that decision. And it also says in the statute that the network is also required to re-credential each network provider every 3 years. There's a note there. Again, please do not send your application to TDI, send it to the individual network. But according to Insurance Code, Chapter 10 in the Administrative Code side, you, the healthcare providers, have a right to review the information submitted to support the credentialing application. You can correct erroneous information and the right to be informed of the status of your credentialing or re-credentialing application. That's found in the rule section 10.82 on the insurance side of the administrative code. So the networks must document and create policies and procedures and written criteria for credentialing network providers. Credentialing procedures are part of the network's what they call the work plan as outlined in the Administrative Code 10.81. Quality improvement, this plan should be reported annually. A lot of the network requirements are located in Chapter 10 of the Insurance Code's Administrative Code. Those are the rules on the insurance side of things. Again, both our Administrative Code and the Insurance Code will apply in the network situations. That's where it works together, and you need to know how to navigate that. Your map that you received has locations for this Administrative Code information. So let's talk about the network requirements. This is a really important slide. The notice of network requirements. The insurance carrier has to notify the employer of the network requirements. It's the employer that chooses to have coverage that has a network. Okay, so the insured is the employer, but the insurance carrier that's contracted with this network has to notify the employer of the network requirements. The employer is required to get a signed acknowledgement form from each employee, which states that the employee has received the network's information and requirements. Like, hey, you are part of a network. You have to choose between these doctors. The employer also has to post notice of the network requirements in their place of employment. And at the time the employer receives a first report of injury or notice of the injured employee must be notified then too. So 3 different times. Upon hire, posting network requirements in the place of employment, and then after an injury. And this information can be looked at closer in 1305.005. Let's talk about the injured employee requirements. They must select a treating doctor from the network's list of doctors. And when the network is putting together their list of treating doctors, they can decide which specialties belong in the treating doctor list of providers available to the injured employees. It may or may not include chiropractors for treating doctors. So the injured employee needs to pick one of the treating doctor options for them that's part of that network. Now, once they pick that, they're entitled to their very first choice. But if they've changed their mind and they want to change their original selection of treating doctor, they can choose the other doctor without an approval within the network. But if they're going to choose another one, say a third doctor, they want to change a third time, the network has to approve subsequent requests for that. Continuing with the injured employee requirements. If the injured employee did not receive approval from the network for a non-emergency healthcare by an out-of-network provider, they might be liable for payment of that medical bill. If the injured employee never received notice of the network requirements from their employer, then the injured employee is not required to comply with the network requirements. And the insurance carrier is liable for paying the medical care until the employee receives notice. So that is a big incentive for the employer and the carrier to let the injured employees know about the network requirements. As far as treating doctor requirements, the treating doctor provides health care to the injured employee, makes any necessary referrals to other network providers, or asks for special permission if they need to send an injured employee for medically necessary services that are not available within the network. They must follow the network's pre-authorization requirements, adopted treatment guidelines, and return to work guidelines. And this all can be found in your contract. And they must participate in medical case management as required by the network, including return to work planning, because again, our mission in the workers' compensation system is to provide high quality medical care. Thus, the evidence-based treatment guidelines and return to work guidelines enough to help the injured employee return back to the Texas workforce. So the contract and those contents of that contract need to get to the right people in your clinic. So if you have a pre-auth department and they know that they're treating a XYZ network injury, they need to know what the treatment guideline is for that injury and the return to work guideline. It may be the same guideline or it may be two different ones. Non-network is the ODG for treatment and MD guidelines for return to work durations, but the networks may have chosen a different one. So read those contracts, make that information available for your staff. Now let's talk about network accessibility and availability requirements. The network is required to have a provider panel that includes an adequate number of treating doctors, specialists, and other types of healthcare providers like facilities who must be available 24 hours, 7 days a week within the network service area. And the network has to arrange for non-network or out-of-network services if a skill or specialty is not available in that network's service area. So if you're a treating doctor taking care of a network claim and you need to get your patient to a specialist that is not in the network, you need to work with that network to help arrange for that out-of-network exception. The provider panels or contracted providers must also include facilities, as I've mentioned, all types of facilities, and they must make available emergency care that the injured employee or ill employees might need, and this is without restrictions on where they can seek emergency care. So if I'm a network claimant, which I happen to be because we work for the state of Texas, if it's an emergency, I can go anywhere for healthcare. But the provider panel should have hospital services, psychiatric hospitals, specialty hospitals available in their provider panel. So what is the network liability for out-of-network care? Say it's approved or has to be addressed for your patient. Does the network have to pay for out-of-network care? The answer is yes. The insurance carrier that contracts with the network is liable for payment in the instances of emergency care that we talked about, or health care for an injured employee who does not live in the service area, or any approved out-of-network care. So those are some 3 exceptions where the carrier is still liable and it is paid like non-network services most of the time. So network liability for out-of-network healthcare. Continued. When requesting approval for referrals to out-of-network providers, the network must approve referrals no later than the 7th day from the referral request being made. And you want to make sure that you get the approval in writing from the network. We talked about documentation in one of our other videos. If you didn't document it, it didn't happen. So make sure you're documenting all the calls and what the carrier says and get something in writing from the network on making that exception. If the network denies the referral for an out-of-network provider, the injured employee may appeal through the network's complaint process. And a special note, if you're dealing with one of these and you get written approval to go out of network, that's not the same thing as pre-authorization. Those are 2 different tasks. So if you're going out of network, get in writing that you've got approval to go out of network. And if the service requires pre-authorization, make sure that's obtained too, because those are 2 different questions and 2 different tasks. It's not the same thing. Let's talk about your intake and registration procedures. You need to identify injured employees whose injuries are subject to a contract or a network, because if you misstep here, you risk non-payment just because you don't have a contract. So you could fall off that climbing wall and you could risk non-payment. And we don't want that for you. So having a really good registration and intake process is important. Here are some best practice recommendations from us on your intake procedures. Some standard verification questions should be first to determine if the injured employee is seeking health care for a work-related injury or illness, or that they believe it's work-related. This should be asked of every patient that's coming in the door, so you don't miss one. And have the injured employee sign something that says it is or it isn't what they believe is a work-related injury. If they say this during intake, you need to ask more questions. The insured is the employer, like I talked about, so you must find out where they were working when the incident occurred. It is conceivable that the injured employee has changed jobs since the injury happened or no longer works there where the incident occurred. So they could have a couple of claims out there and not be working for the employer that where they had the accident. So you want to ask who the employer is where they were injured. Once you find out that employer, you may start asking and verifying if that employer was had chosen to be a subscriber, meaning have coverage, is a political subdivision like the school district or city or county, like the first responders we've talked about. You need to know this to find out if this is a network injury or not. So all the same person could have multiple injuries. One is a network injury and one is not. Just make sure you know who they were working for at the injury at the time of the injury and the approximate date of injury. That is important for intake and registration. Once you find out that the employer is a subscriber or was covered on that date of injury, you want to begin asking if the injury is subject to a network. You can ask multiple people, like ask the injured employee. Remember, they're supposed to be notified that they're part of a network. The referring healthcare provider, say you're an orthopedist office or radiology, ask the referring healthcare provider. The employer, of course. The employer is the insured. The employer is the one that chose to be part of, not part of a network, to offer healthcare services through a network. So the employer is a good person to ask, or the insurance carrier or adjuster. Sometimes people call our claims and customer service and maybe they'll get the answer there or not. But again, the employer is the person that, or the insured that chose to be part of that network or not. So once you find out the injury or the claim is network, find out if your healthcare provider is contracted, because if not, and it's not an emergency, you're going to need special out-of-network permission in writing, or you could be denied and fall off that climbing wall when it comes to submitting your bills. If your healthcare provider is not contracted, you can request in writing special approval to treat as a non-network or out-of-network provider before treating the injured employee. Now, if it's an emergency, of course, this is waived. And I want to repeat that an approval to treat an out-of-network as an out-of-network provider is not the same thing as a pre-authorization. If they need, you get the first hurdle taken care of, they still need pre-authorization. That is a different task that needs to be addressed. Here is a flow chart we put together several years back. This might be a good handout for your intake and registration staff to follow for any intake dealing with workers' compensation. So we have the legend there with all of we love our abbreviations. So take a look at that, blow it up. Your handout should have a full-size picture of this to give to your intake and registration staff. Maybe even your billing staff would like to know what should have happened up front. Let's talk about the pre-authorization and how you can reduce your risk for non-payment because you treated an injured employee who's subject to a network and you needed pre-authorization for the services. So Insurance Code 1305 and Subchapter H, utilization review, are the regulation that surround this. So the labor codes, which is the regular workers' comp, pre-authorization requirements do not apply to healthcare provided through a network. Now, pharmacy is an exception to that. We'll talk about that in the next slide. So basically, you need to look at your contract on what needs pre-authorization and how to conduct that pre-authorization. I would take that part of your contract, if you don't want to share the entire contract, and send it to your pre-authorization staff to make sure they know what they're dealing with for that particular network. So knowing it's workers' comp when it walks in the door, it being the claim, we know these are people. We need to understand what you're dealing with, so everybody's got instructions on how to handle it. I talked about pharmacy. Pharmacy is carved out of 1305. So it's carved out of the network process. So all non-network and network injuries follow this configuration for pharmacy pre-authorization requirements. We have a closed formulary that applies to both non-network and network injuries. And within that closed formulary, it includes all FDA-approved drugs. And to the right, the exceptions are the ones that need pre-authorization. So it kind of looks open because we say all FDA-approved drugs, but it's closed because we have exceptions. Doesn't mean your patient, your injured employee, cannot receive drugs that are not included in the closed formulary. It just means you have to get pre-authorization. And the three exceptions are any drugs with the status of N. This is in the Appendix A of the ODG. We also publish the N status drugs on our website for free. You can look them up under N for N status drugs. So N, in a practical sense, stands for needs pre-authorization, although officially is probably not first line, but N means needs pre-authorization. Investigational or experimental drugs need pre-authorization, or the pharmacy probably won't dispense to your injured employee. All prescription drugs that are created through compounding. So you may have all drugs that don't have an N status in your compound, but just because it's compounded, you're going to need pre-authorization. So it doesn't matter if it has an N status as part of that compound or not. Just because it's compound, you need pre-auth. Also, a note, if you're the doctor writing the script or the PA or APRN writing that script, and you're going to send your injured employee off to the pharmacy's at a big disadvantage, and so is the injured employee, to obtain pre-authorization. Our rule doesn't say who needs to get pre-auth, it's just that it needs to be pre-authorized. The person that's writing the script is the best person to put forth medical justification and request that pre-authorization. So best practice is the person that's writing the script for a drug that needs pre-authorization should obtain that pre-authorization. So each contract with the healthcare provider outlines the network pre-auth requirements and process. And remember, pre-authorization is not required for emergency treatment or services. But once they are on your floor, if you're a hospital, you need to proceed with pre-authorization as soon as possible. If the carrier's utilization review agent has pre-authorized treatment, payment may not be denied for medical necessity, similar to the non-network process. So you also need to know that pre-authorization does not guarantee payment. We taught that on the non-network side. So all it does is say that the carrier thinks it's medically necessary. So that reason for denial is off the table. The carrier may not deny for medical necessity if they've said before the services are rendered that it is medically necessary through pre-authorization. So they can, however, look at other things. On this slide, it tells you that your medical bill may be denied for reasons not related to medical necessity. That could be compensability, extent of injury, relatedness, or liability. We call that CERL, C-E-R-L. Maybe you've coded or billed it wrong, or your documentation doesn't support what you've billed. If you're not timely in filing your medical bills, or you're treating a patient that's subject to a network and your doctor doesn't have a contract with that network, you could get denied payment for some of these reasons also. You need to take care of all of this ahead of time if you can. Get your bill out timely and code it correctly. Let's talk about billing. And some of that's covered in 1305-153, provider reimbursement, and our rule on the Workers' Comp Administrative Code, Chapter 133. Chapter 133.1 shows the exceptions to the billing rules that apply to network claims. So all of our billing rules apply to network claims with these few exceptions. So it talks about the exceptions that do not apply to network claims, including medical documentation, which the networks may decrease those documentation requirements or maybe increase them. Some of the provisions of medical payments and denials, fee disputes, which we'll talk about, these are handled differently, and we'll cover that later on in the presentation. The medical billing rules, the same as non-network side. Healthcare providers must submit their bills within 95 days from the date of service, with some exceptions. We've talked about that in previous presentations. The insurance carriers may or must pay, reduce, or deny those medical bills within 45 days from receiving a complete medical bill, or they determine to audit, and they'll let you know. There's some provisions for them if they're going to audit. So keep this in mind. If your bill is returned because it's not complete, your 95 days is still ticking. Get your bill complete and submit it within 95 days. If you're going to change a CPT code, make sure you do that within 95 days from the date of service. Staying on top of your accounts receivables is important here. The contracts that you've signed determine your reimbursement. The exceptions we talked about earlier are emergency care, healthcare provided to an injured employee who doesn't live in the service area, or you've gotten out of network approval. The non-network fee guideline would apply in those instances. Also, designated doctor and RME examinations are required medical examinations. Referred doctor, maximum medical improvement and impairment rating exams, and when the treating doctor conducts impairment rating exams. The reason these two bullets are on here is because no discounts can be applied to these workers' comp specific services. And for those of you out there that are part of carriers or networks, remember, you may not apply a discount to workers' comp specific services like maximum medical improvement, impairment ratings, extent of injury exams, RME exams, referred doctor exams, even if they're in your network, and treating doctor impairment rating exams. The treating doctor MMI exams are subject to the networks, but the rest, network discounts, but the rest of them are not. You are supposed to, and the carriers are supposed to pay the MAR. And those exam fees are on our website under C for conversion factor or C for certifying doctor examinations. We have a chart out there for 2026 rates. Also treating doctor examinations to define compensable injury, which doesn't happen very often. Now, a note there that the first two bullets, those rules changed in June of 2024. You cannot apply those discounts. Also on your EOBs, there are some requirements for the EOBs. They must include the name of the network. So you on the healthcare provider side, when you look at that explanation of benefits, you should be able to identify the network on there. So networks that are listening in and carriers, make sure your EOBs follow and comply with our rules. Now, if there's a pharmacy, DME, or home healthcare services that are participating in an informal voluntary network, that name needs to be on there when applicable. Let's talk about those now. So reimbursement for pharmacy services can be administered several different ways. First of all, not through a network. It cannot be part of a healthcare certified workers' compensation healthcare network. And if they were, which they are not, there's direction of care, meaning the injured employee would be told to go to which pharmacy. They cannot be offered through a network, so that means injured employees can go to any pharmacy they choose to go to because it's carved out of the network statute. So the reimbursement can be according to our DWC non-network fee guideline. If the insurance carrier negotiates a contract with that particular pharmacy that includes a fee schedule, maybe there's some direct contracting for informal voluntary networks, and there's a negotiated contract. But the injured employee, again, can go to any pharmacy they choose to go to. But there are allowances in our statute for informal voluntary networks. And that's just a negotiation on the fee schedule, not direction of care, meaning telling the injured employee to go to one pharmacy or another. They can go whichever pharmacy they choose to go to. So that's on the pharmacy side. Now let's look at DME and home health services. These are services that are provided through a certified network, or reimbursement shall be made according to the contract. Or if it's provided out of network and that's approved, then that non-network fee guideline would apply. However, a carrier may pay fees that are inconsistent with the non-network fee guidelines if there's a direct contract between the carrier and the healthcare provider through an informal voluntary network. So the statute allows a little bit of carve out for DME and home health services. You can go to I for informal network on our website to learn more about informal voluntary networks for DME, home health, and pharmacy. Now let's go over network dispute resolution for those network injuries or claims. They follow along with the non-network process for the most part, except for when it comes to fee disputes. So let's go over the dispute type. And when we say dispute type, you are reading your EOB to determine which of these disputes, which of these defenses or denial reasons are on your EOB. That will determine your dispute path. So when you call into Comp Connection, you say, my bill has been denied. We're going to ask you to read your EOB, or we're not going to be able to tell you how to dispute that and how to resolve that. So reading your EOB, the first type of denial could be on compensability, extent of injury, relatedness, or liability. We call that CERL, C-E-R-L. Those go through the DWC Benefit Dispute Resolution Hearings process, also known as Benefit Review Conference. And there is no timeline. There's no deadline to file for DWC's Benefit Dispute Resolution Hearings process. There's another video out there in training on resolving medical bills denied for compensable extent, relatedness, or liability. Number two, you've been denied for medical necessity. That is a different denial reason than CERL, or compensable extent, relatedness, liability. Those are two different hurdles that you have to overcome to be paid in our system. So if you're denied for medical necessity, then you would follow the appeal process and the IRO organization process. If it's not one or two, it falls under all else, which is number three, medical fee disputes. That's when you're going to follow your network complaint process. So 1 and 2 are similar to the non-network dispute resolution or administrative remedies. Number 3 differs. You're going to go through the network complaint process. Let's talk in depth or a little bit more about CERL disputes. There's a special provision in the network regulation that gives network providers information about the carrier disputing compensability of an injury in writing. This provision is not found on the network side, meaning the carrier is not required to send a copy of the notice of dispute to the healthcare provider on the non-network side. But on the network side, the carrier network, it is required to send the notice of compensability to the healthcare provider. Notice it doesn't say extent of injury in that bullet. It's only about compensability. And it doesn't come out, the regulation doesn't come out and say they should be sending you a copy of the PLN1. They could, as fulfilling their compliance, but they have to let you know there's a question about compensability ahead of time, as soon as they question it. So on the non-network side, the healthcare providers have to ask for it and hope that they get it from the adjuster or find out during pre-authorization. Carriers are supposed to let the healthcare provider know about outstanding disputes on compensability, extent, relatedness, or liability. Now, the carrier may not deny, based on compensability, the payment for medically necessary healthcare services provided to the injured employee before notifying the network provider. So if they, the carrier, haven't told you there's an issue about compensability, they're still supposed to pay your bills. They need to let you know about compensability. Again, it doesn't address extent of injury. So compensability is when they're supposed to let you know. On the network side, if the insurance carrier successfully contests compensability, they're still liable to pay up to $7,000 of reimbursement provided before notifying you of that compensability denial. That's found in 1305.153E. So just like non-network claims, if the carrier disputes compensability, extent, relatedness, liability, the dispute remedies follow the same path. These paths include a benefit review conference first. That's sort of like mediation, where everybody may or may not agree. If they agree, it's over at that point. The next step, if it's not agreed upon, goes to a contested case hearing where we have an administrative law judge that's going to make a decision. And then if it's appealed after that, it goes to our appeals panel within the division. And if someone's still not satisfied, they can go out to district court if not resolved through our administrative remedies for SURL disputes. Now let's talk about network medical necessity disputes. I have a flow chart here with citations of the network pre-auth and concurrent review process. It gives you your timeframes to appeal. So basically, you're going to make your request. If you get an adverse determination, you're going to make your appeal. And then after the appeal, it goes on to an IRO. And while it's at the IRO, the Independent Review Organization, that's a different company than the carrier and their utilization review agent. So a different set of doctors will look at it. And this is the process with the IRO. And I won't go over it in detail. You have a full handout for this. And you can also find it on our website with all the timeframes and the citations. So very similar to the non-network side of medical necessity disputes. There's a few nuances there. So pay attention closely to the timeframes in both the pre-authorization and retrospective medical necessity disputes and the IRO review process. Now, if it's not the first two, remember, SURL, medical necessity, and you've got some sort of denial on there, then it's going to fall under this category, network fee disputes. Again, it's a network complaint process. If you have a network fee dispute for a network claim, and you're a network provider for that network, that dispute will be resolved through your network complaint process. And as we mentioned earlier, DWC's medical fee dispute resolution process is not the appropriate place to submit a dispute for a network denial. If you file a dispute with DWC's MFDR, it's going to be dismissed. There are some exceptions, of course. For out-of-network healthcare providers that were approved to see a network claim, you can go through the MFDR process. Emergencies that went or network claims can go through the MFDR process. So those exceptions we talked about can go through medical fee dispute resolution. But if you're a network provider, you're contracted with that network, and it's not the first two types of disputes, you're going through the complaint process. Let's talk about the network complaint process. Each network is required to have a complaint resolution system in place. So if you hear otherwise, it is in statute. So they have to have a network complaint process. We've received calls in Comp Connection where the healthcare provider calls the insurance carrier and they're notified of the EOB denials and told they must file MFDR, medical fee dispute resolution, with DWC. That's incorrect. When we get these calls, we tell them, the healthcare provider, to call back and reference insurance code 1305, subchapter I, 1305.401, and to file the complaint. If you're not sure which dispute process to call, then which dispute process to pursue, because it can be confusing, please call us at Comp Connection and we can point you to the correct dispute path. We don't want you to waste your time, nor come into we've got lots of disputes, so we don't want to have either your time or our time wasted by filing an MFDR when you need to go through this network complaint process. So insurance code 1305.401 states that the network may require a complainant to file a complaint not later than the 90th day after the date of the event, or the occurrence. That's the basis of that complaint. So don't waste your time pursuing another process. There is and could be in your contract a deadline. So insurance code 1305.402 says that the network is required to acknowledge receipt of your complaint not later than the 7th calendar day after receiving your complaint, with a description of the network's complaint procedures. Remember, they have to have written procedures about how they handle complaints and their deadlines. And they're also required to investigate and resolve that complaint not later than the 30th calendar day after the date the network received your complaint. And section 1305.403 says they must maintain a record of that complaint and the related proceeding. Also in 1305, it prohibits the network from retaliating or taking retaliatory action against an employer or an employee just because they filed a complaint. It also says that the network requires a contracted healthcare provider to post notice in their office to the injured employees about the process for resolving network complaints. So if you're a network provider, I'm sure during the contracting process, they're going to tell you need to post that notice in your treatment area. So if you have an unresolved complaint filed with the network or a dispute through an insurance carrier on whether the injured employee lives within the network service area, or where you're dissatisfied or disagree with their decision on your complaint, you may file a complaint with the Consumer Protection Department through the TDI portal, which we have a link there on your slide. And that can be found in Chapter 10 Rules, Submitting Complaints to the Department. Now let's talk about the network report cards. So if I'm a healthcare provider and I want to know kind of the lay of the land and how the networks are working, we do have some report card information on our website. We have a research and evaluation group that's within Texas Department of Insurance, and they evaluate the impact of the workers' compensation healthcare networks on the cost of administering workers' comp in Texas for networks, the quality of the medical care provided to our injured employees that are subject to networks, and they publish a biennial information report card. At the beginning, when we first went to the networks back in 2005, the legislation said that we would publish it annually. Now it's every other year. So you should expect one at the end of this year. On the even years, we're publishing a network report card. The network report card results, again, they're posted on our website. If you go to N for networks, you're going to see all the network report cards that we have. And some of the topics that they cover in that report card are the injured employees that are part of a network, are they getting to a doctor on time? Do they have the right access to care? What are their return to work outcomes? This is important when you're looking at your doctor's return to work outcomes compared to what the network report cards say. What are your health related outcomes? Are your injured employees getting quality health care? Are the injured employees satisfied with that care? And what are the costs and utilization of healthcare on the network side? Could be interesting. Not 100% of networks are looked at, but they're looked at in groups, and some of the larger ones are looked at. So look at the network report cards to get the lay of the land. So what we've covered today is what is a certified workers' compensation network? How can you join one? Network requirements, your intake and registration procedures, your pre-auth requirements, medical billing and reimbursement, dispute resolution, and the report cards. So let's see how lucky you are today, and we're going to flex your knowledge. First question is, when a healthcare provider wants to join a workers' compensation certified network, where do they send the completed application? Okay, the answer is you've got to send that application directly to the network. So the middle answer is correct. Do not send your credentialing application or your network application to either DWC or MCQA. You have to send it to the network. We don't broker those contracts, so send them directly to the network. Question number 2. Does a healthcare provider's intake team need to determine if the injury is a network claim or not? That is true. If you want to be paid, you need to check that status of that injury to make sure your healthcare provider is contracted with that network if it's a network injury, or get special out-of-network permission. Number 3, each contract with the healthcare provider outlines the network's pre-auth requirements. That is true. Look at your contract to determine your pre-auth requirements. There's 22 networks out there. You need to check and see how many you're contracted with and what it says. Number 4, generally reimbursement for healthcare provided to a network claim is determined by the contract. That is true. Everybody got that one right. Love that. Number 5, network fee disputes are resolved through the network complaint process, not through MFDR. True. That is true. I had some exceptions up there, but do not file an MFDR, and then you're going to be waiting for us to dismiss it, and then you're going to have to file it with the network complaint process. You may miss their deadline to file their complaint. So pay attention to that, and I appreciate you participating in this polling situation here, flexing your muscles. We're making our way through the obstacle course. We have climbed that wall, and we will be in the tent next. We'll be talking about billing and reimbursement training for designated doctors and other certifying doctors. So the learning objectives while you're in the recovery tent is to recognize current billing requirements and reimbursement values, apply the billing instructions by example for each doctor's role, designated doctors, required medical exam doctors, referred doctors, and treating doctors we will discuss in the next video. If you have questions for us, you can always call us at Comp Connection. The 800 line, option 3 is us. Option 1 is claims and customer service. Option 3 is the hotline, if you will, for doctors. Or email us at compconnection@tdi.texas.gov. And thank you for watching today.